Okay, so let's unpack this.
Let's do it.
Today we're diving deep, really deep, into something absolutely fundamental. I mean, it's at the very heart of how a democracy, well, works, right?
Yeah, absolutely. The bedrock.
The rule of law itself. We're going to look at how justice, in the real world can be, well, challenged, especially under pressure.
Yeah, looking at that interplay, politicization, pardons, even retaliation, it's complex stuff.
Definitely. And our whole exploration today, it's kind of framed by two really significant events, things that happened in the first half of 2025 that really impacted American rule of law norms.
And these weren't small things, right? Not subtle shifts.
No, not at all. Very visible actions that, well, a lot of observers think really reshaped the justice landscape in the U.S. So our central idea for this deep dive, the thesis, if you like, is that this combination is called selective enforcement on one hand and institutional weakening on the other.
That combination is the core challenge.
Exactly. It's the core hazard to the rule of law. And importantly, this isn't just some abstract theory, right?
No, absolutely not. This is a live unfolding scenario. It has really profound implications for how government actually functions.
Okay, so here's the plan. We're going to systematically look at how some people argue the Justice Department has been, well, influenced, bent maybe, to serve political ends.
We'll dig into the changes, the structure, the people.
Yeah, personnel changes, actions taken against lawyers, law firms, which is pretty striking.
And those international parallels, too. Are there common patterns elsewhere?
Right, crucial context. We'll also look at how the courts responded. Where did they push back? Where did they maybe enable things?
That's a mixed picture there, for sure.
And finally, we'll scrutinize the rhetoric. What the administration says versus what observers see actually happening.
Comparing the statements to the reality on the ground.
Exactly. So, for you listening, expect a rigorous analytical approach. We'll get into the specific mechanisms, the facts as reported, and what it all means. We're aiming for those aha moments, making sense of a really complex situation. The unprecedented shifts of early 2025, a dual challenge emerges.
Okay, so to really get a handle on this, we need to go back to right after President Trump's inauguration in 2025. Almost immediately, within 5 months, two key things happened.
Right, the ones you called seismic earlier.
Yeah, pretty seismic. The first one was a campaign promise fulfilled, came right on January 20th, 2025, Inauguration Day itself.
Oh, wow, day one.
Well, technically, Jan 20th is Inauguration Day, so yes. President Trump granted pardons to nearly all 1,590 individuals charged or convicted related to the January 6th Capitol attack.
All of them. Nearly 1,600 people.
Nearly all. It wasn't piecemeal. It was broad clemency. For the vast majority, it just wiped the slate clean, legally speaking.
And that includes, what kinds of offenses are we talking about?
Well, to clarify, the reports indicate this included people convicted of serious offenses, like assaulting police officers with pipes, chemicals, that sort of thing.
Wow.
It also extended to commuting sentences for some of the higher profile figures who maybe didn't get a full pardon but got their sentences cut.
And the justification. How did the administration frame this?
The stated reason was national reconciliation. President Trump called the January 6 prosecutions a grave national injustice. So he positioned the pardons as correcting that, fixing what he claimed were politically motivated cases against his supporters.
And the immediate impact, apart from clearing those individuals.
Well, the immediate impact was huge. It effectively protected people the administration saw as, regime loyalists. It exempted this whole class of people, his supporters involved in Jan 6, from legal consequences.
Right.
And that's where many legal observers really raised concerns. They argued this fundamentally challenges the whole idea of the universality of law.
Meaning the law should apply to everyone equally, regardless of politics.
Exactly. This act suggested to them that legal consequences could be selective, based on political allegiance, not impartial justice.
Okay, so that's the first major development, a massive wave of pardons. What was the second shoe to drop?
That followed pretty quickly by June 2025, so less than 5 months into the term.
Still very early days.
Yes. And this involved the dismantling of a key part of the Justice Department, the Public Integrity Section, often called PIN.
Okay, PIN. Remind us why this section was so important, its history.
Right. Context is key here. PIN was founded after Watergate.
Ah, okay. That tells you something.
It really does. It was specifically designed as this elite unit to prosecute political corruption. But crucially, it had a built-in safeguard.
Which was?
It required approval from the section before any U.S. attorney could charge a public official. It acted as a gatekeeper.
To prevent politically motivated prosecutions.
Exactly. It was meant to ensure decisions were based on legal merit, not political convenience. A bedrock of impartiality, many considered it.
So, a crucial check within the system. And what happened to it in June 2025?
Well, the reports describe it as being weakened with really astonishing speed and thoroughness.
How so?
By June, PITI was reportedly stripped of its authority to bring new cases. Almost all its staff were removed. It went from over 30 experienced prosecutors down to just 5.
Wow. Gutted.
Completely. And that critical gatekeeping role.
Huh.
The one meant to prevent political prosecution.
Yeah.
Suspended.
Sure.
Suspended.
The implications of that sound
Significant.
stark and immediate, according to observers. It effectively freed up Trump-appointed U.S. attorneys across the country to pursue charges against politicians without PIN's oversight.
Without that impartiality check.
Precisely. A former DOJ official is quoted, warning this could make it easier to prosecute Trump's opponents and spare his allies, directly raising alarms about the rule of law.
So bypassing that internal check, opening the door, critics would say, for selective justice.
That's the core concern, yes.
Okay, so let's connect these two things then. The mass pardons for allies on one side. For regime loyalists, as they saw it.
And the weakening, the gutting of this key anti-corruption unit on the other.
When you put them together, they become these really vivid illustrations of that thesis we started with.
Selective enforcement plus institutional weakening.
Exactly. They're not just random events. Critics argue they're two sides of the same coin, working together to fundamentally change how justice operates.
This makes me think about that distinction. Something really crucial for anyone interested in political science or legal philosophy.
Yes. The difference between rule of law and rule by law.
Explain that for us, because it sounds subtle, but it feels really important here.
It's absolutely critical. So in a system governed by the rule of law, the law itself stands above everyone, including the rulers, the people in power.
It constrains them impartially.
Right. It ensures everyone, top official, ordinary citizen, is subject to the same rules, applied universally based on the law itself, without fear or favor.
Okay, that's the ideal, was rule by law.
Rule by law is different. That's where legal mechanisms, the courts, the statutes, they're used not to constrain power impartially, but as a tool to entrench power.
So the law becomes a weapon.
Essentially, yes, a weapon in the hands of the ruling power. It might be applied very strictly against opponents.
Well, allies get a pass.
Exactly. Relaxed or ignored for allies. The legal system becomes an extension of political will, not an independent check.
And you're saying these 2025 events point towards that second model.
That's the argument. The mass pardons exempting political supporters look like selective enforcement. Dismantling POM, removing an independent check, looks like institutional weakening. Together, critics contend, they shift the system dangerously towards rule by law.
Okay, let's do a quick micro recap here, about 5 minutes in. Early 2025 saw this dual challenge emerge.
Right. First, mass pardons shielding allies, undermining the universality of law.
Second, the systematic weakening of the DOJ's anti-corruption unit, removing a key check on politically motivated prosecutions.
And taken together, these actions really embody that core theme. Selective enforcement paired with institutional weakening. 2, shifts and systemic politicization at the Department of Justice.
Okay, so moving on from those first two big shocks. What came next seems like an even broader effort. Observers describing it as a sweeping shift and politicization campaign.
Yeah, starting pretty much day one of Trump's second term, not gradual at all. An immediate, decisive restructuring aimed right at the Department of Justice.
And where did it start? What were the first targets?
One of the earliest and most striking moves, according to reports, was going after the special counsel investigations.
The ones looking into Trump or his allies previously.
Exactly. Within days of the inauguration, the acting Deputy Attorney General, Emil Bove, reportedly directed this nationwide effort to shake up the department.
Not just a routine shuffle.
No, explicitly focused, reports say, on officials involved in those specific investigations. Reuters reported in late January 2025, so just weeks in, that more than a dozen prosecutors who worked on special counsel Jack Smith's cases against Trump were either fired or forced out.
And the result for those cases?
Dropped. promptly dropped once Trump took office, according to reports. Critics saw it as basically ending accountability by just removing the people pursuing the cases.
Wow.
And beyond the special counsel cases, did this reported purge go further?
Oh, yes. It seems it went much broader, particularly concerning the January 6th investigation.
The biggest criminal probe in DOJ history, right?
Exactly. An internal memo reportedly directed the FBI to compile lists of everyone who worked on the Jan 6 cases and other investigations deemed politically sensitive.
Compile lists for what purpose?
The stated premise, according to reports, was to identify people for removal, based on the assertion that their work amounted to weaponization against Trump.
Weaponization, that word again.
Right. And by the first week of February, still incredibly early, the FBI was reportedly instructed to fire hundreds of agents based on this. Observers argue it wasn't about job performance. It was about perceived loyalty or involvement in investigations the leadership didn't like.
Hundreds of FBI agents. That's a huge number. What about leadership?
Also hit hard, reports suggest. At least 5 top FBI officials in major cities, D.C., Miami, Philly, New Orleans, Las Vegas, ordered to resign or be fired in one fell swoop.
A clean sweep.
Pretty much. Another senior official in L.A. followed soon after, and this was after 5 senior officials at FBI headquarters had already been pushed out earlier that same week.
So a rapid decapitation of experienced leadership.
That's how some analysts described it, yes.
Yeah.
Removing layers of institutional memory and independent judgment.
And how did people react to this, particularly within law enforcement?
The reactions were strong and immediate. The FBI Agents Association, which usually stays out of politics, reportedly issued a public warning. What did they say?
They warned that dismissing hundreds of agents would severely weaken the Bureau's ability to protect national security and fight crime. Their focus was operational capacity.
They saw it impacting the actual work.
Oh, yes. And others were more pointed. National security lawyer Bradley Moss reportedly called it a raw, unfiltered exercise of presidential authority to purge anyone who put the Constitution first instead of loyalty to Donald Trump.
Word words.
Very. And Senator Mark Warner called the reported firings deeply alarming, worried about crippling America's first line of defense amidst global threats. So concern was widespread.
This wasn't just the FBI, though, right? You mentioned the Justice Department's own lawyers.
Indeed.
Yeah.
Career attorneys within DOJ reportedly faced similar upheaval, reassignments that some called forced repurposing, an overt and unusual campaign, according to sources.
How many people are we talking about?
Reuters reported in late January around 20 senior DOJ lawyers were reassigned, and what stood out was that many were described as apolitical veterans, people who'd served under both parties.
Not political appointees, but career staff.
Exactly. Former officials called this kind of mass reassignment of senior career people unusual and against typical department practice, a real break from norms.
Can you give us examples? What kind of expertise was being moved?
Sure. One key name mentioned was Corey Amundson. He was the chief of the Public Integrity Section.
The very section being weakened.
Precisely. Known for nonpartisanship, served across administrations, suddenly moved out just as Pinnen's powers were reportedly being cut.
That seems pointed.
Another example, Yoon Young Choi. She headed DOJ's cryptocurrency enforcement team, and she had notably prosecuted a dark web criminal whom President Trump had just pardoned. Her reassignment, critics argued, spoke volumes.
Wow.
Randall Eliason, a former federal prosecutor, reportedly characterized these moves not just as odd, but as a broader assault on expertise in government, a deliberate sidelining of independent voices.
And where did these experienced lawyers end up? Were they just fired?
Not all of them. Reportedly, several were sent to this newly created unit, the Sanctuary Cities Enforcement Task Force.
Set up specifically
to aggressively challenge state and local governments, resisting Trump's immigration policies.
So, taking lawyers from anti-corruption or national security.
And redirecting them towards politically charged immigration enforcement. Work directly aligned with the new administration's agenda. Critics saw it as turning nonpartisan professionals into tools for a partisan agenda.
And what about the immigration courts themselves? Any changes there?
Yes, reports indicated parallel moves there too. At least 4 top career officials at the Executive Office for Immigration Review, the body that runs the immigration courts, were outright fired.
Including the director, including the agency's director and the chief immigration judge. These roles were historically nonpartisan, meant to ensure some impartiality.
So removing them allowed.
Allowed the administration to install loyalists, potentially steering immigration outcomes in a direction more favorable to their policies. Critics saw it as a coordinated effort across DOJ divisions to align the entire legal apparatus with the administration's political goals. Okay, and who was seen as orchestrating these moves within DOJ? The driving force, according to multiple reports, was Attorney General Pam Bondi. Her role seemed central.
Right. Let's talk about her confirmation. That sets the stage, doesn't it?
It really does. Bondi, a known Trump loyalist, was confirmed February 4th, 2025, along party lines. During her hearings, she did vow to maintain DOJ independence, said she wouldn't inject politics.
But people were skeptical.
Very skeptical, reportedly. Given her history defending Trump during impeachment, echoing his 2020 election claims, many felt her primary loyalty was clear from the start.
And once confirmed?
She reportedly became a key instrument for Trump's promised retribution campaign. On day one, Trump signed an executive order directing the AG to review all departments for weaponization or political bias, the weaponization review.
Exactly. Bondi launched these sweeping reviews, and critics noted the outcomes predictably aligned with Trump's grievances, targeting units or people who previously investigated or opposed him.
And under her leadership, specific enforcement areas were affected.
Yes, reports say DOJ leadership paused or curtailed multiple lines of enforcement Trump didn't like.
Such as?
For example, by February, they reportedly suspended all investigations of U.S. companies for overseas bribery. That impacts FCPA enforcement, anti-corruption efforts.
Significant for international business ethics.
Hugely. The FBI task force on foreign election interference reportedly disbanded despite ongoing warnings about threats.
Wow.
In April, reports say DOJ ordered prosecutors to step back from crypto fraud cases. That drew scrutiny because of the Trump family's known interest in crypto, though the White House denied any connection.
And, as we discussed, the public integrity section.
Reportedly crippled entirely, impacting federal anti-corruption efforts that might have scrutinized Trump or his allies.
And how is all this justified publicly?
The overarching narrative was ending the weaponization of government. A DOJ spokesperson defended the changes, arguing local, presidentially appointed U.S. attorneys were better placed to decide corruption cases than a D.C.-based integrity unit with far too much power.
But veteran observers didn't buy it.
Not according to reports. Former Republican DOJ official Stuart Gerson was quoted as aghast, warning directly of the politicization of the justice system. He said flatly, "The rule of law is endangered." A fundamental shift, in his view.
Let's look at the Civil Rights Division. Was that impacted too?
Yes, that division provides another really stark example of how priorities reportedly shifted, seemingly by pressuring career staff.
How so?
Soon after Bondi took office, reports say her DOJ immediately halted investigations into systemic police abuse. That had been a major focus previously, addressing unconstitutional policing patterns.
A big change in direction.
Huge. And simultaneously, the division reportedly launched an investigation into the Los Angeles government. Not for civil rights issues, but over whether LA's gun control laws violated the Second Amendment.
So, pivoting from police oversight to gun rights.
Exactly. Prioritizing an issue central to Trump's cultural agenda over the division's traditional mission, as critics saw it.
Any other shifts in focus?
Yes, reports say the division also reversed prior positions on transgender rights, opposing protections. And it began probing universities for alleged anti-Semitism related to pro-Palestinian protests.
Again, aligning with the administration's cultural and political priorities.
That's how critics interpreted it. Seeing the division's resources steered by ideology, not neutral enforcement of civil rights law, and instrumentalization of a key legal arm.
Were there personnel changes there too? Did staff react?
Yes. Personnel actions seem to underscore this transformation. In April, 7 Democratic senators wrote to DOJ expressing concern.
About what specifically?
They noted actions that looked like attempts to purge or intimidate career attorneys. DOJ had reportedly reassigned about a dozen senior career lawyers in civil rights that month, including section chiefs handling policing and voting rights.
And the senator's interpretation.
They explicitly said these actions seemed designed to cajole career officials to leave voluntarily in order to fundamentally transform the division. They stressed the need for expertise and neutrality, implying it was being undermined.
Did this affect morale more broadly in DOJ?
It seems so. Around the same time, reports surfaced about the federal programs branch, the lawyers who defend administration policies in court.
What happened there?
Insiders described a punishing workload of dubious cases and a real fear of being asked to make unethical arguments. The result: two-thirds of the attorneys in that branch reportedly either quit or announced plans to leave.
Two-thirds. That's a massive exodus.
Huge. One departing lawyer reportedly asked, how could they participate in the project of tearing it down? It highlights a significant brain drain of nonpartisan talent, as professionals felt unable to square their ethics with the administration's demands.
So by mid-2025, what does DOJ look like, according to these analyses?
The picture painted is an institution largely led by Trump loyalists and stripped of many institutional checks. Bondi and Trump's former personal lawyers reportedly in top posts, shifting the focus to Trump's priorities and grievances.
Driven by politics, not law.
That was the criticism, that political expediency was overriding independent legal principles.
And the career professionals.
Systematically marginalized, re-signed, or driven out en masse, according to various reports. A loss of experience and nonpartisanship that changed the department's character.
Any other checks removed?
Yes, even internal oversight was reportedly impacted. Trump had also fired many agency inspectors general, the internal watchdogs, or left posts vacant, removing another layer of independent scrutiny.
What did legal experts make of this overall picture?
Andrew Kent, a constitutional law professor, reportedly warned it was utterly unprecedented, very dangerous steps for a democracy, eroding independent checks on executive power. The overall signal, critics argued, was clear. Loyalty to the president now trumped fidelity to the law.
Was this loyalty requirement ever made explicit?
Reportedly, yes. Attorney General Bondi issued a memo in February 2025 threatening disciplinary action against any DOJ lawyers who didn't vigorously advocate for Trump's agenda in court.
Wow. What did the memo actually say?
It stated career attorneys could not substitute personal political views or judgments for those that prevailed in the election.
How was that interpreted?
Many lawyers reportedly saw it as an edict. Push legally questionable arguments or face consequences, maybe even firing.
And were those fears realized?
Reportedly, yes. A senior lawyer in immigration litigation was fired in March after apparently hesitating to press an extreme legal position. He later filed a whistleblower complaint, alleging he was asked to make unsupported legal arguments and distort precedent. DOJ denied his claims, but the chilling effect on remaining attorneys was described as palpable. So, pulling it all together, the reported personnel changes, structural shifts, the loyalty memo. What's the alleged outcome?
The view of many critics is that Trump and Bondi systematically impacted the traditional independence of federal law enforcement, reshaping DOJ into an instrument to shield allies and potentially punish enemies.
Which is that selective application of law.
Exactly. The hallmark of what critics call autocratic rule by law, where law serves power, not justice.
Okay, time for a mega recap of this section on the shifts at DOJ. Let's hit the key points.
All right, first, purge tactics. Reports of firing, reassigning Trump investigation prosecutors, Jan 6 FBI agents, ousting FBI leadership.
Then, DOJ career reassignments. Unprecedented moves of senior career lawyers to politically charged roles.
Next, Pam Bondi's role. Confirmed as AG, reportedly implementing the weaponization review, halting anti-corruption efforts, gutting public integrity.
And the civil rights redirection, shifting focus from police abuse to gun control, transgender rights opposition, probing protests, leading to mass resignations in some branches.
Finally, the loyalty mandate. Bondi's memo reportedly threatening discipline, leading to alleged firings and a chilling effect on legal integrity. The cumulative effect, critics argue, profoundly reshaped federal law enforcement. 3. The targeting of the legal profession. Allegations of retaliation against lawyers and law firms.
Okay, so we've looked inside the DOJ. Now let's zoom out to what some observers call maybe the most striking illustration of that rule by law idea, which is the alleged campaign by the Trump administration to target the legal profession itself. Specifically, reports of retaliation against lawyers and law firms seen as hostile.
So, using state power against private lawyers.
Exactly. This is where that abstract concept becomes really tangible. The state reportedly trying to impact the independent function of legal representation.
That sounds extraordinary.
It was described as an extraordinary campaign, directly wielding presidential power to target attorneys whom he perceives as hostile.
Who fell into that category?
Reportedly, lawyers representing opponents, those who worked on investigations against him, or even firms advocating for causes the administration disliked. It's an alleged level of intrusion by a president into the private practice of law that many find unprecedented.
And how is this targeting carried out? What were the tools?
The primary method reported was explicit executive orders and proclamations, singling out specific law firms for alleged punishment.
Naming firms directly in presidential orders.
Yes. By March 2025, reports say no fewer than 5 major U.S. law firms had been hit by such orders. An unprecedented intrusion, many called it. Critics saw it as a clear attempt to disrupt the right to counsel and deter independent legal advocacy.
Can you walk us through some examples? How did this reported campaign unfold?
Sure. It reportedly started with somewhat limited actions in February against Covington and Burling, a firm known for ties to a prominent former AG. That involved suspending security clearances for some lawyers.
Okay, a first step. But it escalated.
Significantly, according to reports. March 12th saw an executive order aimed at Perkins Coie, a well-known firm with Democratic ties, which Trump openly accused of weaponizing the legal system.
And what did that order entail?
It was sweeping. It would have reportedly stripped all Perkins Coie attorneys of their federal security clearances, basically barring them from classified work. It would have barred them from access to government facilities, and even started proceedings to cancel federal contracts held by the firm's clients.
Targeting the clients, too. Wow. That's a direct economic assault.
Absolutely. But in this case, there was a check.
The courts.
Yes. A federal judge swiftly blocked most of the Perkins Coie order, calling it likely unconstitutional. Huge First Amendment and due process concerns.
Did the administration acknowledge the reasons for targeting?
Well, notably, one administration proclamation reportedly openly admitted they were punishing firms for things like donated free legal work on immigration or voting rights things Trump opposed, and even for generic discrimination via diversity initiatives, punishing legal advocacy itself.
Which the court saw as unconstitutional.
Right. But Trump reportedly wasn't deterred by that ruling. He shifted tactics.
How so?
The next target reported was another big firm, Paul Weiss, and this ended differently. Sources describe a perverse settlement.
A settlement. What does the firm agree to?
Paul Weiss reportedly agreed to donate $40 million in free legal services to administration-approved causes and to publicly profess nonpartisanship in its hiring, all in exchange for the order against it being withdrawn.
$40 million and a public statement aligning values. That's immense pressure.
Immense. And Trump reportedly boasted about it, claiming firms were lining up for similar deals. He apparently said in April, "We have another 5 to go," suggesting a clear strategy of leverage, critics argued.
Did he name other firms?
Yes. Late March, another proclamation reportedly hit WilmerHale, a top national firm.
Why WilmerHale?
The targeting was explicit, citing its past association with Robert Mueller, the special counsel who had returned to the firm.
So retaliation for the Mueller investigation.
That's how it appeared. The order was similar, reportedly suspending all security clearances, cutting off access to federal officials, directing reviews to terminate client contracts. The White House reportedly called it part of a broader effort against lawfare.
Did the pattern continue?
Reportedly, yes. Jenner and Block faced a similar order. Then in April, Sussman Godfrey, a Texas-based litigation powerhouse.
And their alleged offense?
Representing Dominion voting systems in those defamation suits against Trump allies like Giuliani and Sidney Powell over the 2020 election lies.
Ah, the Dominion lawsuits.
Exactly. The White House proclamation reportedly accused Sussman Godfrey of undermining American interest and even criticized its diversity program. The order was just as severe, reportedly revoked all security clearances for its 170 lawyers, banned access to government buildings, threatened client contracts.
Relentless pressure. But did the courts continue to push back?
They did offer some resistance. By this point, 3 firms, Perkins Coie, WilmerHale, and Jenner and Block, had sued and reportedly won preliminary injunctions blocking enforcement.
So judges were consistently finding these orders problematic.
Yes, consistently finding the firms were likely to prevail because the orders were likely unconstitutional. One judge explicitly wrote the president's actions likely violated the U.S. Constitution, a direct rebuke.
So judicial pushback was happening.
Yes, demonstrating that some checks were holding. Meanwhile, another major firm, Skadden Arps, reportedly entered negotiations like Paul Weiss, agreeing to provide free legal work to avoid being targeted, further illustrating the coercive pressure, critics said.
How did the broader legal community react to all this? Were lawyers concerned?
Concern is putting it mildly. Reports describe widespread outrage, a unified condemnation you rarely see.
Who spoke out?
In late March, 20 Democratic state attorneys general and the American Bar Association, ABA, publicly warned these actions pose dangers to the U.S. legal system by chilling lawyers' freedom to choose their clients.
So a threat to the core function of legal representation.
Exactly. ABA President William Bay reportedly declared never been a more urgent time for the ABA to defend its members, the profession, and the rule of law. A sense of fundamental challenge.
Did the ABA do more than issue warnings?
They took an extraordinary step in mid-June. They actually sued the Trump administration in federal court.
The ABA sued the president.
Yes. Seeking an injunction to stop what they called a campaign of intimidation against law firms. They cited the string of executive orders as blatant violations of the Constitution.
And they had legal precedent by then.
Right. 4 major firms had already won court orders blocking Trump's actions, strengthening the ABA's case. And tellingly, one of those firms, Sussman Godfrey, the one targeted over Dominion, was now representing the ABA in its lawsuit. A real sign of solidarity, observers noted.
Did the ABA argue this was already having an effect, a chilling effect?
Yes, strongly. The lawsuit argued Trump's actions already had a chilling effect. They pointed out the ABA itself had struggled to find lawyers willing to sue the federal government for them.
Because firms were afraid of retaliation.
Exactly. Due to that pervasive atmosphere of fear, as the ABA put it, they accused Trump of a deliberate policy to intimidate and coerce lawyers into not challenging the administration. A major confrontation between the nation's largest bar group and a sitting president.
And the White House response?
Defiant, reportedly. A spokesperson called the ABA suit frivolous, claimed broad presidential discretion over contracts and clearances, promised ultimate victory, and dismissed the targeted firms as sanctimonious, indicating many felt no intention of backing down.
Okay, so looking at the outcomes here, it's mixed, right?
Definitely mixed. On one side, you have significant legal roadblocks. Courts enjoin orders against at least 4 firms, showing the judiciary could act as a check. A glimmer of hope for resilience.
But on the other side,
Trump also had what some called successes. By June, 9 law firms had reportedly succumbed to pressure and quietly struck deals.
the Paul Weiss and Skadden Arps model.
Exactly. Pledging nearly $1 billion worth of free legal services to his chosen causes to avoid being targeted or get orders lifted.
$1 billion. That's staggering. It shows the leverage.
Huge leverage. Critics argue it highlights the extortionary pressure. Firms may be calculated that sacrificing fees and some independence was better than sustained government.
Punishing.
Right, that's a key point. Fighting these battles costs immense resources, takes time, damages reputations, regardless of the legal outcome.
So the chilling effect is real, even with court victories.
Widely described as real, yes. Lawyers reportedly hesitating before taking cases that might attract negative attention from the administration. The ABA itself citing difficulty finding counsel for its own lawsuits due to this atmosphere of fear.
Did the administration target the ABA in other ways, beyond criticizing his lawsuit?
Yes, the pressure reportedly extended directly to the ABA as an institution. The administration allegedly cut federal funding for an ABA program assisting domestic violence victims.
Seen as retaliation.
Widely perceived that way, yes. Retaliation for ABA criticism of Trump's judicial nominees and policies. The administration also reportedly moved to strip the ABA of its role in accrediting law schools, a critical function.
Did the courts intervene there?
Again, yes. A federal judge issued an injunction in March blocking the DOJ from canceling a $3.2 million ABA grant for that domestic violence program. Judicial resistance again.
But the pressure continued.
Reportedly. Attorney General Bondi also allegedly threatened the ABA's accreditation authority unless it dropped a diversity requirement for law schools, linking it to Trump's campaign against woke policies.
So the message was clear.
The message, critics argued, was that any organized body of lawyers challenging the administration could find itself in the crosshairs.
This whole campaign against lawyers, does it echo patterns seen elsewhere? Internationally?
Experts say yes, absolutely. It echoes tactics often seen in what they call authoritarian playbooks.
Oh, so.
Using state power to punish attorneys who represent rivals or disfavored groups, that's described as a hallmark of illiberal regimes.
And the goal?
Strategically, analysts argue, it's to deny the opposition access to competent legal representation, weakening their ability to challenge the government, and removing that buffer of professional independence that lawyers provide.
But the scale and openness in the U.S. context, that feels new.
The brazenness, as critics describe it, stands out. A law professor noted, We've never had an administration pushing the legal envelope so quickly, so aggressively, and now against the legal profession itself. A significant escalation for many.
Is there an analogy that captures that chilling effect well?
Yes, a quote cited from the Indian context is powerful. People are harassed to coerce them into joining the ruling party. If I join today, I will also stop getting summons.
The implication being...
For the U.S. legal system, critics suggest it's chillingly similar. If I join Trump's team, the pressure stops. How politicized law can coerce loyalty and suppress dissent.
So summing up this section on targeting lawyers.
Trump's reported actions have alarmed attorneys across the political spectrum. They see it as an assault on the independence of the bar and the right to counsel.
By making legal opposition costly?
The administration challenges a key pillar of rule of law, lawyers' freedom to advocate without fear of reprisal. This reported tit-for-tat revenge mindset, punishing adversaries, rewarding allies, twists the legal system into a patronage tool, critics argue. Politicization in the extreme.
Okay, another mega recap. Section 3. Targeting the legal profession.
Key points. Tactics involved reported executive orders targeting firms with severe professional consequences, security clearances, facility bans, client contract threats.
And the deals. Reports of firms making multi-million-dollar donations of legal services to avoid targeting.
Followed by legal pushback. Federal judges issuing injunctions, finding the targeting orders likely unconstitutional. 4 firms reportedly won these injunctions.
And the legal community response. Widespread condemnation, state AGs speaking out, and the ABA taking the unprecedented step of suing the administration for a campaign of intimidation, causing a chilling effect.
Finally, the authoritarian parallel. Weaponizing state power against lawyers is seen by experts as a hallmark of illiberal regimes aiming to deny legal counsel to the opposition. 4. Global echoes. International parallels in the erosion of rule of law.
Okay, we've looked inside the U.S. system, at the DOJ, at the legal profession. But this wouldn't be a deep dive without looking outwards too, right?
Absolutely. The U.S. in 2025 isn't operating in a vacuum. When we talk about these pressures on the rule of law, there are really troubling parallels in other countries.
Revealing maybe a common playbook.
That's what some analysts argue. A common playbook for regimes seeking to consolidate power. And studying these parallels gives crucial context, maybe a warning about how quickly checks and balances can unravel.
So where should we look first? What's a key example?
Poland, especially from 2015 to 2023 under the Law and Justice Party, PS. It's seen by many as a stark case study in systematically capturing the justice system for partisan ends.
Capturing the justice system. How did they reportedly do that?
After coming to power, PS launched what observers called an open defiance of the law, the Constitution, and the courts, explicitly aiming to take control of the judiciary.
What were the mechanisms, the specific steps?
Several key moves. First, they merged the office of Justice Minister with that of Prosecutor General. One person, a staunch PS loyalist named Zbigniew Ziobro, held both roles.
And the effect of that merger?
Critics argued it eliminated any independent prosecutorial authority. The power to investigate and charge was placed directly under political control.
Okay, step 1. Control the prosecutors. What else?
Second, they reportedly purged judges and prosecutors deemed insufficiently loyal. They overtly used disciplinary proceedings to intimidate dissenters, created a climate of fear.
So, pressure the judges.
Right. Third, when Poland's constitutional tribunal, their top court, tried to block the government, officials reportedly just refused to publish the court's decision.
Refused to publish them, making them legally void.
Effectively, yes, in the view of critics. And at the same time, they stacked the tribunal with party loyalists, paralyzing its ability to act as an independent check.
And how did PS justify this?
Reportedly, quite bluntly, they argued the courts have no right to interfere with the people's will, as represented by the ruling party.
The consequences.
A full-blown constitutional crisis, according to many. It led the European Union to trigger Article 7 proceedings, a serious step for rule of law violations. Poland, under PS, critics contend, shifted decisively toward rule by law. Prosecutions used to protect allies and harass opponents.
But PS is out of power now.
Yes, voted out in late 2023. But the new government is now struggling with the incredibly difficult task of trying to restore the rule of law after years of institutional damage.
So the relevance for the U.S. context.
Poland shows how a determined ruling party can neutralize oversight and co-opt prosecutions, often using populist rhetoric about fighting a corrupt elite a narrative some find echoes Trump's weaponization claims.
Okay, Poland is one example. Where else are we seeing parallels?
Israel provides another striking case, particularly from 2023 onwards. A historically stable democracy now, many argue, deeply troubled by its government's attempt to radically curb the judiciary's powers.
This is the Netanyahu government's judicial overhaul plan.
Exactly. Prime Minister Netanyahu's right-wing coalition launched this plan aiming to strip the Supreme Court of much of its review power and, crucially, give the ruling coalition decisive control over judicial appointments.
Directly targeting judicial independence.
That's how critics saw it, yes. Dismantling the court's ability to check executive and legislative power.
What was the key piece of legislation?
A bill passed in July 2023 that eliminated the court's authority to void government actions deemed unreasonable. It passed 64-0 because the opposition boycotted in protest.
And the reaction?
Enormous public outcry, mass protests across Israel.
What was the government's justification?
They claimed it was necessary to stop an interventionist judiciary, to restore power to elected officials who they said had been overridden by the courts.
But critics saw it differently.
Vehemently. They warned it would open the door to abuses of power, undermine democratic safeguards.
And there's a personal element for Netanyahu too, right?
Yes, that's often highlighted. He's currently on trial for corruption. Many believe weakening the courts or changing judge selection could help him evade accountability or get more sympathetic judges.
How has the Israeli public responded?
It's been described as awe-inspiring. Huge protests, hundreds of thousands in the streets week after week, military reservists refusing service, deep concern expressed even by Israel's president and international allies about the nation's democratic health.
What did the protests signify?
Slogans like dictatorship or fears of a state of religious law reflect this profound fear that once the courts can't act as a check, the ruling majority has virtually unlimited power.
Where does it stand now, as of mid-2025?
Parts of the overhaul were paused or moderated due to the backlash, and Israel's Supreme Court is actually reviewing the legality of the laws passed. So judicial resistance plus massive public opposition have slowed things down, at least.
And the parallel to the U.S.?
It's that pattern. A leader facing legal trouble, Netanyahu indicted, Trump indicted, reportedly trying to change the rules of the game to avoid accountability while claiming to restore some lost balance.
Okay, Poland, Israel. Any other key examples?
India, under Prime Minister Narendra Modi and the BJP since 2014, offers another important parallel, especially regarding weaponizing law enforcement.
Weaponizing agencies against opponents.
That's the charge from many observers and the opposition, using agencies like the Enforcement Directorate, ED, the Financial Crimes Unit, and the Central Bureau of Investigation, CBI, disproportionately against opposition leaders.
Disproportionately. Is there data on that?
Yes. Reuters reported that since 2014, the ED opened investigations into nearly 150 opposition politicians, but only around 4 from Modi's ruling BJP faced similar scrutiny.
150 versus 4. That's a stark imbalance.
Extremely stark, raises immediate red flags about impartiality, critics argue.
Did this intensify around elections?
Dramatically, reports say, especially before the 2024 general election. Opposition leaders faced raids, arrests, and asset freezes on what they called politically motivated charges.
Any specific examples?
The arrest of Arvind Kejriwal, Delhi's chief minister and a prominent Modi critic, in March 2024, just a month before voting began. Rahul Gandhi, the main opposition leader, said the BJP crippled his party with tax investigations, even freezing their accounts. He called Modi a scared dictator who wants to create a dead democracy.
Is there evidence that switching sides helps?
That's one of the most striking points. Many opposition politicians under investigation reportedly defected to the BJP, and once they switched sides, the investigations against them were often dropped or went dormant.
Wow, that's incredibly blatant if true.
It led India's Supreme Court and international observers to question this misuse of laws. Is enforcement demonstrably one-sided? Modi insists the agencies are independent, just fighting corruption. But the data, the timing, the outcomes, many argue it strongly suggests rule-by-law tactics, using legal tools to sideline opponents. Watchdogs cite it as democratic backsliding. And the relevance for the U.S. here.
Critics draw a direct line. Just as Modi's government allegedly uses the CBIED against the opposition, Trump's rhetoric and reported actions suggest a desire to unleash U.S. law enforcement on his own rivals. He's talked openly about it. India shows how that kind of campaign can fundamentally impact an entire democratic playing field.
Okay, so these international cases, Poland, Israel, India, each offer a different facet, a different warning.
Right. Poland, the capture of prosecutorial power, defying courts. Israel, mass public resistance to judicial castration. Selective legal crackdowns muffling opposition.
And what's striking is that the U.S. under Trump's second term, according to many observers, seems to exhibit elements of all three.
How so?
You see an executive reportedly seeking direct control over prosecutions, like Poland. You see what some call open disdain for judicial checks and celebrating a Supreme Court that curtails them, echoing Israel. And you see a clear embrace of selective law enforcement, like India.
So understanding these global patterns helps us recognize the dynamics potentially at play in the U.S.
Exactly. It's not just academic. It helps you, the listener, grasp the patterns of democratic erosion and potential trajectories.
Let's do a quick micro recap here, maybe 15 minutes in. We've looked at how Poland reportedly captured judicial power, Israel faced mass protests over judicial changes, and India allegedly uses selective legal crackdowns.
Right. And the key takeaway is that the U.S. situation in 2025 seems to echo troubling elements from all these international examples.
Okay, time for the mega recap for Section 4, Global Echoes.
Right. Poland showed capture of judicial power via merging prosecutor-justice minister roles, purging judges, paralyzing the top court.
Israel highlighted a leader facing legal peril, seeking to change rules via judicial overhaul, curbing the Supreme Court, sparking mass protests.
India demonstrated selective enforcement, rule by law, via weaponization of investigative agencies, ED, CBI, disproportionately targeting opposition politicians.
And the U.S. echoes. Trump's reported actions show elements of all three, seeking executive-controlled prosecutions, judicial challenges, and embracing selective law enforcement, via the courts. A tug-of-war for accountability.
Okay, so we've seen the internal DOJ shifts, the international parallels. Now we absolutely have to look at how American courts have responded in 2025.
And you said earlier it's a mixed picture.
Very much a mixed picture. A real tug-of-war, you could say, between judicial resistance on one side and maybe accommodation or enabling on the other.
Let's start with the resistance. Where have courts pushed back?
There have been definite glimmers of resilience, especially from the lower federal courts, district courts, some appellate panels.
Like with the law firm cases.
Exactly. As we discussed, judges issued those injunctions blocking Trump's most brazen actions, like the orders blacklisting law firms. In those instances, many argue, the judiciary acted as it should, checking executive overreach that likely violated constitutional rights, like free speech, due process.
So some judges applying the law rigorously.
Yes. Similarly, when the DOJ reportedly tried to punish the ABA by yanking grants, a federal judge enjoined it as unlawful retaliation, preventing funding from being used as a political weapon.
What about the fired officials? Are their lawsuits getting anywhere?
Early days, but there have been some favorable rulings allowing discovery to proceed in cases brought by fired DOJ FBI officials. A willingness, at least, to scrutinize those personnel decisions.
Any examples at the state level or involving federal-local conflict?
Yes. At times, state or local courts have blocked Trump administration initiatives seen as overstepping authority, like the reported attempt to take direct control of Washington, D.C.'s local police. A federal judge issued a temporary restraining order citing serious separation of powers questions.
So these pockets of judicial pushback are important.
Very important. They show, critics say, that not every judge has acquiesced. There's still a cohort of life-tenured judges reportedly applying the law conscientiously, serving as crucial bulwarks.
Okay, but that's the lower courts. What happens when we look higher up, specifically at the Supreme Court?
That's where the narrative really shifts, according to many analyses. The court's firmly conservative majority has, in the view of many, largely tilted the balance in Trump's favor, delivering him what some call sweeping victories that narrow the path for accountability.
And the biggest one was the immunity ruling.
Undoubtedly. The ruling on presidential immunity in mid-2024, just months before Trump returned to office, Trump v. United States, a landmark case.
What did it decide?
It was truly significant. The court held that a president enjoys absolute immunity from criminal prosecution for core official acts, and even for other acts, there's a strong presumption of immunity if the conduct had any colorable connection to presidential duties.
Absolute immunity for official acts. What's the practical effect of that?
In effect, critics argue, the court erected a shield around Trump for much of his conduct related to trying to overturn the 2020 election.
And the reaction from legal scholars.
Immediate and widespread criticism, called unfounded in precedent and dangerous. The Brennan Center described it as an affront to democracy and the rule of law, warning it practically invites future presidents to use the levers of government to commit crimes under the cover of official acts.
Did the court claim this aligned with the founders' intent?
The conservative majority reportedly claimed it restored the vision of a vigorous executive. But historians quickly countered that the founders explicitly intended presidents to be accountable to the law, never intending blanket criminal immunity. A divergence from original intent, some argued.
And what did this mean for the January 6th cases against Trump specifically?
Profound impact, many argue. By shielding official acts, it undercut the Jan 6-related prosecutions pending against him. Special counsel Jack Smith's case alleging obstruction of the election certification was reportedly largely impacted. The ruling explicitly directed federal prosecutors to drop allegations tied to Trump's commandeering of the DOJ to try and overturn the election. And it created that daunting presumption of immunity for his other related actions. Critics argue this effectively forced the dismissal of that case soon after Trump took office, which his new DOJ was positioned to do anyway.
So this immunity doctrine is now a major hurdle.
A huge hurdle to accountability, many call it. If a president can argue an action, even an abusive one, was part of official responsibilities, they might be untouchable by criminal law.
Does it give a green light for future abuses?
Legal analysts argue it effectively does. A president could potentially use federal agencies against opponents, frame it as policy, and claim immunity. Or challenge court orders. As one analyst put it, it endangers democratic accountability by potentially shielding presidents from prosecution for trying to impact elections. The Supreme Court, critics contend, has narrowed the scope of the rule of law at the very top.
Beyond immunity, did the Supreme Court make other decisions that helped Trump's agenda?
Yes, another key area was nationwide injunctions. Those lower court orders that can block a federal policy across the whole country.
Trump often complained about those, right?
Yeah.
Single judges stopping his policies.
Exactly. And responding to those complaints, the court's conservative majority sharply limited lower courts' ability to issue nationwide relief.
How did they limit it?
They ruled injunctions should generally be no broader than necessary to remedy the plaintiff's injuries. Meaning, relief might now be confined just to the specific people suing, not everyone affected nationwide.
What's the practical effect of that? Sounds technical.
Profound practical implications. It makes it much harder for challengers to freeze a questionable policy everywhere while the case is ongoing.
And has the Trump administration used this?
Reportedly, yes, strategically. They press forward with controversial measures, knowing that even if one court rules against them, it might not stop the policy elsewhere.
Can you give an example?
When Trump reportedly tried to freeze $2.5 billion in federal funds to Harvard, and a court blocked it in Massachusetts, the DOJ argued the injunction should only protect Harvard, forcing others to file their own suits, fragmenting the challenge.
Or the birthright citizenship issue.
Similar dynamic reported there. Attempts to end birthright citizenship by executive fiat met multiple lawsuits. Even when one judge granted a nationwide injunction, DOJ reportedly sought to limit it and pursue the policy in other circuits.
So the result is fragmentation, buying time.
Exactly. Allows the administration to implement policies unevenly, maybe long enough for a sympathetic Supreme Court to eventually uphold their actions, despite lower court resistance.
Okay, so the Supreme Court decisions lean towards executive power. But are there still signs of judicial integrity, even at lower levels?
Yeah.
Any potential red lines?
Yes, it's important to stress that pushback continues. Some Trump initiatives, like reported attempts to prosecute state officials for not enforcing immigration orders, have been stymied by judges who found no lawful basis.
So judges still saying no based on the law?
Yes. In one notable case, a federal judge reportedly threw out a DOJ indictment of a local election official, calling it retaliatory and lacking evidence. A powerful message against political prosecutions, some argued.
And the law firm cases we talked about.
The fact that 4 different judges from both parties, reportedly granted injunctions, shows a strong consensus that Trump's targeting of lawyers violates core constitutional norms.
What norms specifically?
They consistently emphasize First Amendment protection for legal advocacy, the right to counsel, and that the president cannot punish private speech or legal representation he dislikes. Those decisions reportedly remain in force, a persistent judicial bulwark there.
Any hints of concern even from the Supreme Court itself? About going too far?
Subtle hints, perhaps, about overt politicization. For instance, when faced with a hypothetical about a brazen attempt by Trump's DOJ to arrest a federal judge, a scenario floated in fringe circles. Even the most conservative justices reportedly signaled that would be a red line.
Interesting. So some fundamental lines might still hold.
It suggests that, yes, some rule of law red lines might hold, even with an executive testing boundaries, a sign that even a sympathetic court might balk at certain actions.
So summing up the court's role in 2025, it really is this tug of war.
Exactly. Lower courts providing some immediate bulwarks, showing resilience. But the Supreme Court, through key rulings like immunity, has for many shifted the legal landscape in favor of executive power and reduced accountability.
And the practical result is fewer avenues for accountability.
Many traditional avenues, criminal prosecution for presidential misconduct, nationwide injunctions have been narrowed or closed, critics argue. What's left are slower case-by-case legal battles, public opinion, and Congress.
But with Congress largely aligned with Trump and a sympathetic Supreme Court.
The judiciary's role as protector of rule of law has been diminished, many contends.
Is the system breaking or just bending?
Commentators often say bending but not breaking. Individual judges show integrity, but the overall system's ability to restrain an executive determined to test the limits is under severe strain, raising questions about long-term health.
It reminds me of that Justice Robert Jackson quote.
The loaded weapon, quote. Yes, if the court blesses expansive powers, it becomes a loaded weapon ready for the hand of any authority. In 2025, many argue we're seeing that loaded weapon in action, underscoring why the fight for rule of law is also a fight for the judiciary's soul.
Okay, final mega recap for this section on the courts.
Right. Lower courts showed resilience, reportedly blocking abuses like law firm blacklisting and the ABA grant cancellation via injunctions, immediate bulwarks.
Supreme Court expanded presidential immunity for official acts, Trump v. United States, impacting Jan 6 prosecutions against Trump. Also limited nationwide injunctions.
Outcome: a tug of war. Lower courts provide some checks, but SCOTUS has largely tilted the balance toward executive power, reducing accountability avenues, according to critics.
And the big picture. The judiciary is bending but not breaking, but its ability to restrain an executive testing limits is under severe strain, impacting checks and balances and the rule of law itself. 6. Rhetoric versus reality. Depoliticization is a justification.
So throughout this whole complex story of 2025, there's one thing the administration has been very consistent about.
Which is?
Their public narrative. They consistently claim to be depoliticizing a Justice Department that was previously weaponized against conservatives. Everything they do is framed as a necessary corrective.
That weaponization theme again.
It's central. President Trump, in a March 2025 speech, reportedly accused the prior Biden administration of using law enforcement to thwart the will of the American people. AG Bondi and others reportedly echoed this, saying DOJ is just refocusing on real crimes like violent crime, immigration, moving away from so-called witch hunts.
And what justifications do they offer for specific actions?
Yeah.
Like getting penance?
They cite things like rising crime or the border situation as the rationale for shifting resources. For weakening public integrity, spokespeople claimed it was giving power back to local U.S. attorneys, stopping one D.C.-based unit from having far too much power.
And targeting law firms.
Framed as fighting entrenched interests or partisan lawyers who supposedly weaponized the system against Trump. The overall claim is they are removing politics from justice by purging those they label as political or biased, presenting it as restoring impartiality.
Okay, so that's the rhetoric. Now let's dissect it. Why do critics argue these justifications don't hold up?
The fundamental argument from critics is that the administration's own actions are inherently overtly political, that they're actually using DOJ as a blunt instrument to reward friends and punish enemies. Not depoliticization, but hyper-politicization.
Let's take that public integrity example again. How is weakening it not depoliticizing?
Critics argue it's the opposite. Weakening the anti-corruption unit directly allows Trump's allies to escape scrutiny while enabling partisan prosecutions of rivals. PIN was designed specifically to prevent politically motivated cases. Suspending its oversight is seen as a green light for exactly the weaponization Trump claims to oppose.
Is there a past example of PIN stopping something like that?
Yes. Reportedly, a Trump-appointed U.S. attorney once tried to indict Senator Chuck Schumer over a 5-year-old comment, stretching legal theory to absurd lengths. It was PIN lawyers insisting there was no case that stopped it. Without PIN, critics fear the next Schumer case sails through more politicization, not less.
Okay, what about the mass firings of career officials? How does that fit the depoliticization claim?
Critics say it directly contradicts it. Firing career officials en masse and replacing them with loyalists doesn't depoliticize DOJ. It politicizes it to an extreme degree. It signals only one political loyalty to Trump is acceptable.
It's seen as an assault on expertise.
Exactly. As one former official put it, in a healthy system, you don't purge people for working on cases the president dislikes. That's associated with authoritarianism. And you certainly don't demand, like Bondi reportedly did, that lawyers park their own conscience and follow the views that prevailed in the election. That's seen as turning lawyers into political soldiers.
So the rhetoric is seen as misleading.
Critics call the fighting weaponization rhetoric deeply Orwellian, using the language of fighting weaponization to justify actual weaponization.
What about the January 6 pardons? Trump framed that as correcting an injustice.
He did. Called the prosecutions illegitimate, a witch hunt against patriots. But critics argue that by exempting an entire class of people, his supporters, from legal consequences, he's undermining the rule of law's universality.
Remind us of the context there.
Over 140 police officers injured. Dozens of rioters convicted on serious charges, including assault. To erase those convictions purely because of political allegiance sends a clear message, critics say. If you commit violence for my cause, you will be protected. Protect Democracy called it licensing future law-breaking. That's seen as the antithesis of depoliticizing justice, making justice explicitly partisan.
And the selective investigations, targeting opponents.
Again, critics argue that selectively launching investigations into state officials who oppose Trump, or openly threatening to prosecute political rivals, which Trump has done, that doesn't remove politics from DOJ. It enshrines politics at DOJ. Targets chosen by political stance, not wrongdoing.
The administration claims they're just enforcing the law equally, unlike the previous one.
Critics say that claim falls apart when you look at the reported outcomes. Under Trump, virtually no allies or Republican figures are being investigated, while Democrats and perceived deep state foes are.
Like the probe into Biden's Afghanistan withdrawal.
Right. Abruptly opened early in 2025, cheered by Trump's camp. But no similar reported zeal for probing alleged misdeeds by Trump allies. When asked about this imbalance, the administration reportedly dodges or repeats slogans about independence. Critics say it rings hollow.
Like the India example again.
Exactly. Modi claims to fight corruption, but 95% arrested are opposition. Trump's DOJ, critics argue based on patterns, shows a similar skew. And Trump's own words like lock her up, chance, make his motivation clear to many, he wants political prosecutions.
So the final point of failure for the justification.
Critics argue it's that the administration conflates accountability for wrongdoing with political witch hunts.
How so?
Was it weaponization when the previous DOJ prosecuted people, including Trump, for alleged crimes like mishandling classified documents or fraud? Trump says yes, blames radical partisans, but many prosecutors were career staff or special counsels with judicial oversight. By reportedly impacting those cases and pardoning convicted allies, Trump essentially asserts, critics argue, that nothing done by him or his allies can ever be legitimate crime.
A declaration of impunity.
That's the argument. The law only applies to the other side. Rule of law says no one is above the law. Trump's practice, critics contend, effectively implies his side is above the law.
Which brings us back to that core distinction.
Rule of law versus rule by law. Rule of law. The law stands above rulers. Rule by law. The law becomes merely a tool used to suppress opponents. Trump's DOJ in 2025, critics argue, despite the rhetoric, exemplifies rule by law, wielding laws selectively to punish adversaries while impacting enforcement for allies. Textbook politicized justice, they say.
And the danger.
As Andrew Kent warned, very dangerous steps for a democracy, because the precedent undermines the system. The justifications offered are seen as perverse inversions of the truth. Shouting, witch hunt, doesn't change the reality, critics argue, that actual injustice is occurring. The injustice of a legal system reportedly bent to serve one person's interests.
Okay, final mega recap for Section 6. Rhetoric versus reality.
The administration's claim, They're depoliticizing a weaponized DOJ, focusing on real crimes, fighting entrenched interests.
The reality, according to critics, actions are inherently political, gutting public integrity, firing career staff, Bondi's loyalty mandate, mass pardons for allies, selective investigations of opponents.
The Orwellian justification. Rhetoric of fighting weaponization reportedly serves to justify actual weaponization of the legal system.
And the core danger. This is rule by law in action, critics argue, using the legal system for power consolidation, eroding the principle that no one is above the law. Outro. Okay, we've covered a lot of ground in this deep dive, when justice bends, and we keep coming back to that core idea, right?
That combination, selective enforcement plus institutional weakening.
Exactly. That's the toxic combination, the core challenge to the rule of law. And what we've looked at today, Trump's actions in 2025, gutting Padilla, sidelining prosecutors, the pardons, targeting lawyers. Critics argue this marries those two strategies together in a way that's just unprecedented in American history.
It's not just about specific policies. It's seen as a systematic approach that redefines the relationship between power and law.
And the consequences. What are the broader systemic effects people are worried about?
They're far-reaching, according to many analyses. First and foremost, the idea of the rule of law itself in the U.S. has been weakened. That basic concept that laws, not leaders, govern has taken a severe hit.
How so?
Well, think back. Nixon said, when the president does it, that means it's not illegal, and he was condemned. Now, critics argue we have a Supreme Court blessing a version of that for official acts, and a president acting like anything he does should be beyond scrutiny, a dangerous shift in norms.
What about public trust in the DOJ?
Severely impacted, many argue. How will future DOJ corruption cases be viewed, even legitimate ones, if the department is seen as a political tool? And conversely, will real wrongdoing by allies go unpunished, breeding impunity and corruption? Critics ask if anyone at DOJ would dare investigate a Trump appointee now.
And the impact on the people working within the system.
A significant erosion of civil service morale and capacity. That brain drain we talked about, experienced DOJ lawyers, FBI agents leaving en masse.
Replaced by
Maybe less experienced people or overt ideologues. This impacts all law enforcement, complex fraud, cybercrime, not just political cases. Critics argue it makes America less safe and just. The FBI Agents Association warned it sets up the Bureau for failure.
And internationally, America's standing.
Also severely impacted, many contend. Harder for the U.S. to credibly advocate for rule of law abroad when leaders can point to the U.S. apparently persecuting opponents. Allies are wary, adversaries reportedly revel in accusing hypocrisy, undermines moral authority.
And thinking back to those international parallels, Poland, India, what do they suggest about reversing these kinds of changes?
They suggest it's not easy to reverse. Poland is struggling to undo the damage. India's opposition hasn't found a way back. It raises a troubling question for the U.S. Even if a future administration wants to restore norms, will the personnel and public trust be there? Or are we stuck in a cycle of seesawing retributions that permanently politicize justice? It's a critical point, because the rule of law isn't just statutes. It's built on norms and mutual understandings, an ethic that law enforcement should be insulated from partisan influence. Critics argue Trump has smashed that ethic with a hammer, normalizing behavior that was once unthinkable.
He might succeed in the short term, shielding himself, advancing his agenda.
Possibly, many analysts concede. Even supporters note a need for people willing to press the legal boundaries. But in the long run, critics argue, this undermines the very idea of law as a check. When pressing boundaries is routine, the boundary disappears. Law becomes just political will.
So, to wrap it all up,
the core challenge is that a leader can, through selective enforcement and institutional weakening, transform the justice system into a tool of personal power. It's not theoretical. Critics say it's unfolding now in 2025.
and the fate of the public integrity section.
A potent symbol, many argue, created after Watergate to ensure no one is above the law, now reportedly weakened when arguably needed most. While nearly 1,600 Jan 6 participants are forgiven and lawyers defending institutions are allegedly challenged. Selective enforcement plus institutional weakening.
The old maxim was, be you ever so high, the law is above you. What's the new one, according to critics?
Based on the observed reality of 2025, it seems to be. If you're on my side, the law will bend for you. If you're not, the law will be used against you. That's rule by law, not rule of law. A path, critics warn, that leads to the erosion of democracy itself.
So for you, our listener, especially with that deep interest in political science, history, philosophy of law, this whole deep dive really highlights an urgent question, doesn't it?
It really does. How do we as informed citizens keep that foundation of impartial justice strong when the lines between law enforcement and political power get so dangerously blurred? What are the mechanisms for resilience when the institutions meant to uphold the law are, as some argue, under assault from within?
It's more than just politics.
Absolutely. It's a fundamental philosophical and practical challenge to the integrity of governance itself. It demands constant vigilance, constant critical reflection from all of us.